Okay, the next case on the docket is State Farm versus BETH CRISPIN.
Good morning.
Morning.
May it please the court, Kara Rockenbach-Link on behalf of the appellant State Farm, and I would like to reserve the 5 minutes for rebuttal, Your Honor. Thank you. Disinterested means disinterested. And a mere 8 days ago, the 4th District Court of Appeal ruled on this very issue, and both appellant and appellee have provided that supplemental authority, which was State Farm versus Valenti. And in that case, Judge Jeffrey Kuntz wrote a special concurrence and couldn't make it couldn't be more crystal clear. He wrote, "It is simple. A person with a direct financial interest in the outcome is not disinterested." So State Farm's asking this court to continue its leadership of clarity in this realm of the law. You started it back in I believe it's 2012 or 2014 with the Bronco decision, which was relied upon recently in the 3rd DCA in the Sanders versus State Farm appeal. Sanders is pending rehearing, and obviously with only 8 days into it, Valenti is still within the rehearing period. But Bronco is the decision from this court that controls the outcome today.
Can you see any circumstances where the public adjuster would be disinterested?
Well, could there be circumstances where he would be disinterested? Possibly, Your Honor.
What would they be?
For instance, he or she doesn't have a contingency fee-based interest in the outcome of the award. Thereby, there's no generating an inflation because it would directly inure to the public adjuster's wallet. So that would be one factor. There would have to be additional factors. I think in this case, in many of these, the public adjuster is the one who writes the estimate, which creates the conflict before anyone mentions appraisal. So perhaps if appraisal is invoked by one or the other side, and then the insured goes out and retains a public adjuster who hasn't written an appraisal, who hasn't walked the property, and before appraisal was invoked, and doesn't have a contingency fee interest in the outcome, then that might satisfy those. In this case, very brief factual background, it's a Hurricane Irma case.
We're familiar with it.
Okay.
So
And
in your view, in the way that the DAC action was framed, the first question is whether a public adjuster can ever serve as a disinterested appraiser. Then the prayer for relief kind of says, can my public adjuster, ever be disinterested? And then there's the other question of whether a contingency, or adjuster using a contingency fee, appraiser contract,
right.
qualify as disinterested. So in terms of the question that we're answering on appeal, what category do you think it falls into?
Well, this one falls in all the ones that are similar in that the Valenti case from the 4th DCA, the Sanders case from the 3rd DCA, Bronco from this court. I know it involved an attorney, but the language from this court's decision compels reversal here, because the language in the Bronco case talks about the fiduciary agency relationship that exists. And in Bronco, talked about that agency relationship. Well, you had that in the record before you. The public adjuster's contract in this case that gives the public adjuster 10% of whatever the award ultimately is actually starts off with Ms. Crispin hereby retains 5-star, doing business as 5-star, to be the agent and representative. So the word disinterested in our contract has to mean something. It didn't to the public adjuster in this case. What's also interesting, and it's in the record attached to State Farm's motion to compel appraisal, is the invocation of appraisal itself, it wasn't invoked by State Farm. It was invoked by the insured, not just the insured. It actually was invoked by the public adjuster, who stood to earn 10% of the proceeds of that process. And in that letter, December 14, 2017, the five-star adjuster, Jay Humphreys, says, the insured has chosen to invoke the appraisal provision in the policy. As you are aware, each party will choose a competent appraiser. So I point this out to the court only because I ran across it this morning and I thought, well, how interesting. Even in their invocation of appraisal, they dropped out the word disinterested. But it's a contract. An insurance policy is like any other contract. The terms and conditions have to, if they are plain and unambiguous, then they have to be applied. And in this case, you can't just remove the word disinterested and ignore it.
Do you think that the code of ethics, or, you know, the administrative code in this case, would ever have any relevance to the term disinterested in a contract in relation to a contingency fee arrangement?
That's a great question. So Judge Sasso, Judge Kuntz asked that question during oral argument in the Valenti case about the code of ethics, and pointed out that the Florida Supreme Court has said arbitrations are not appraisals, right? They are two different, very different animals. Appraisals, the Bronco decision from this court said appraisals are creatures of contract. So to answer that question, I have to give that backdrop. I'm not quite sure how to answer it. I think the code of ethics, the AAA code of ethics for arbitrators, can have some weight, some guidance, and it certainly did change. As the Bronco court pointed out, the Rios and Galvez decisions, which are outdated, I think they're from the 80s, from the third DCA, this court said, we're not following those. They relied on the outdated code of ethics for arbitrators, and in that outdated code, it just required disclosure of this financial interest or disclosure of bias. But the updated code, as this court pointed out in Bronco, requires a preference or a presumption of neutrality. That's a little bit of a higher standard than just disclosure. What is good is disclosure if you can't do anything about it? So the code did change. I guess that's a very long answer to your question. I think I have to answer it that it, just as I started, it has potential weight and guidance for the court, but I can't say that it strictly holds or controls the outcome or the definition of disinterested. I would suggest that this court look to its own Bronco decision, because you define the term disinterested in...
You keep going back to the Bronco case. So
Yes.
But to reverse, would that require me to agree with Orfinger and Wallace?
It might. It might, Your Honor.
It's very difficult for me.
It might.
I don't know.
Well,
I just don't know if I can do that.
Well, you would be, you and they would be in good stead, because you have 3 judges to the south of you and who would agree with that. The Valenti case certainly did embrace the Bronco decision from this court and extrapolated from that decision and said, just because it was an attorney there serving as the appraiser, it makes no difference. There still is that fiduciary duty, that agency relationship. Here we have even more egregious facts, because we have a contract that says clear agent and representative. We have a contract that says I have an incentive, a 10% incentive, to drive up the cost of this appraisal award, because I'm going to make more money if it's higher. I mean, it's just common sense.
Yeah, and I guess following up on that, in terms of, you know, a bright line rule, which I think Judge Kuntz's concurrence would suggest.
Yes.
Would a situation, and not saying this is the facts of this case, but let's say that there is a, you know, code of ethics applicable specifically to appraisers,
Right.
that, you know, create some enforcement authority if an appraiser puts their pecuniary interest above the, you know, disinterested facts of the case, or, you know, that sort of thing. might that remove a contingency contract from disinterested, or still just looking at the plain definition, would that fall into disinterested?
Well, it's interesting you asked that question, because there is the Florida Administrative Code. I think we probably cited it below first, or I know that State Farm has cited it in some of these appeals, and did so in this case. And that code requires the public adjuster to be honest toward its insured, toward its client, and to not place its interests above the client's. So, but that doesn't alleviate or meet the contractual requirement that State Farm and the insured agreed to, which was disinterested. Just because an adjuster says, I promise to be honest to my insured or my client, doesn't mean that he or she comes to the appraisal process with fresh eyes. And that's really what it is. I used that term in the Valenti case, and I think Judge Connor picked it up in his special concurrence. It really is about fresh eyes. It's about all three, two appraisers coming to the appraisal process with nothing tainted. They haven't drawn up an estimate. They haven't walked the property. They don't have a financial pecuniary interest in the outcome of the appraisal. And so that's what it's about. And that administrative code does not fix or satisfy the requirement that's in the insurance contract that both parties deserve, which is disinterested, competent appraisers. So we ask that this court reverse, follow its longstanding precedent that was guiding other DCAs, guiding the third DCA in Sanders and guiding the fourth DCA in Valenti, and is the logical, common sense, right approach to interpreting this plain word in the insurance contract. Thank you.
Thank you.
May it please the court, Matthew Struble for the appellee. For decades, insurers, including State Farms, agreed that a public adjuster can be an appraiser. Then in 2014, this court issued its Bronco decision, which rightfully held that an attorney, completely different, can't be an appraiser. And since that time, insurers, including State Farm, have been trying to stretch this court's precedent to make it essentially impossible for an insured to go through an appraisal process, which is favored in Florida, to not make litigation necessary, to obtain an appraiser so that they can pursue an appraisal process. This court can answer the question that was submitted by the fourth DCA in the concurring opinion in one of our cases very easily, because as I just conceded on the stand, a public adjuster can be an appraiser. And if you look at how this case was framed, that's what was asked for. That's what the actual declaratory judgment said, the final judgment.
Well, the prayer for relief in the declaratory judgment says something along the lines of, can my, the petitioner's public adjuster may serve.
Yep, so there's arguably two issues.
And so the petitioner's public adjuster in this case had a contingency fee contract. And it was more than that, right? That they identified the issues that needed to be appraised, and then were the ones that made the demand for the appraisal, and then actually also served as the appraiser. So when we consider those facts, how could we say that that does not fall into an interested?
So if you look at the record, it's basically replete with no evidence. Unlike the Valenti case where there was affidavits and actual evidence, they filed no evidence, there's no estimates.
We have a contract, though.
You have a contract, absolutely. And
So looking at those contractual terms, how, when we're looking at the plain language of the contract,
right.
how do we conclude that that's disinterested?
So yeah, you look at the plain language of the contract, and as all the pleadings we had set forth makes it very clear, they never said that you can't hire your appraiser by paying them on a contingency fee. And in the pleadings we sent forth examples where other insurance companies in their appraisal provisions added that. Certainly State Farm could have done so. They could have said that in order to...
If you have, it just seems counterintuitive that if you have an interest in the outcome of the process, that I don't see how that lends to a disinterested party.
Yes, so disinterested...
Explain how that isn't counterintuitive.
Yeah, so everybody in this courtroom in some way has an interest in the outcome of this case. We're here, we're giving our time.
I don't care what happens.
Understood, but we're here, so everybody's getting, and it's the same thing with an insurance company, right? What they're trying to stretch it to is there's a third party that eventually becomes involved in the appraisal process. That's a neutral umpire, and the policy specifically provides for that. As to the neutral umpire, both parties have to agree, and the insurance policy actually dictates how that would be paid. It has to be paid by both parties on an hourly basis.
If not, though, an appraiser has a interest in the amount that State Farm pays based on their percentage that they'll recover, what would be an interested party? I mean, if that's not interested, what is?
Yeah, obviously, yourself, if it's your home, if it's a relative, if somebody who has a financial pecuniary interest in the actual property, if it's a business property, if somebody has an actual pecuniary interest in the business property. And when you look at the definition, that's what that means. And when you
With a 10% contingency fee contract, you have an interest in what the amount is that's ultimately the property is appraised at.
you have interest
So,
in that, in the
That's an actual real financial interest.
well, it's an interest in that. That's how the state of Florida has said that that's how people who represent insureds get paid. That's how this is set up. You can either be a public adjuster or you can be an independent adjuster representing insurance companies. You can't have a concurring license. You can only be one or the other. So you can be a public adjuster who represents homeowners, and in order to do that, the payment based on the statute is...
Well, but it's not the representation of homeowners that gives rise to the conflict. It's having a contingent fee arrangement that gives rise to the conflict. I don't think anyone's saying that a public adjuster can't be part of the appraisal process. We're just saying that a public adjuster who has an interest in the outcome of the appraisal process is not a disinterested person.
Yeah, but I think you have to look at the administrative codes because that is who is available for insureds to hire, okay? And particularly when you look at these cases...
Could you hire a public adjuster who you didn't have a contractual relationship with?
I believe that the administrative codes provide that they're paid on contingency fee, and it caps that, and it makes it very clear they can never exceed 20%. And so when you look at who's available for them to actually hire, as all the filings have made clear, it would become cost prohibitive for an insured to ever be able to pursue a claim. You're looking at...
And aren't those kind of extra contractual concerns so that might give rise to valid legal defenses but aren't relevant to what the definition of the term disinterested
I think
is?
the reason they're valid is because State Farm keeps using this Courts Bronco case, which referred to the Florida Administrative Code, and say, hey, these duties make them an agent. But that's not true. When you look at what a public adjuster's actual duties are, all of the duties are related to acting fairly, adjusting the claim, treating everybody fairly, and being unbiased. That's what their actual duties are.
You're suggesting Bronco was decided incorrectly?
No, I think it was absolutely correctly because it looked to what an attorney's duties are. And attorneys have duties of confidentiality and duties of loyalty. You have to look at what a public adjuster's duties are. And you apply that same logic, public adjuster's duties are to fairly and independently adjust a claim. And there's nothing inconsistent with that being an appraiser. And the important thing here is you have to look in the context. Say you have a $10,000 claim. If State Farm is able to force a homeowner to go pay an appraiser on an hourly basis on appraisals, which State Farm can take years, they have to pay more than the amount they could ever possibly recover just to get benefits that they're owed. And that's the extreme danger with how they're trying to stretch the Bronco decision. And they're very well aware of that. You see all the cases that we listed. So if a homeowner has a $10,000 damage, but they need to get their home fixed, if you adopt what they are suggesting, they have to hire somebody, pay them hourly to go all the way through the appraisal process and end up owing them more. So you can look at it as a public adjuster is interested, but in the very same token, they could end up making much, much less money on the smaller case. So it's a very dangerous road to go down and would preclude insureds from being able to pursue cases. And then the only other alternative would possibly be litigation.
When we read a contract, we're supposed to give every term, every word, every item in the contract meaning, correct? You would agree with that?
Yes.
Okay. And you rely upon the fact that there's an umpire, and the umpire could cure any out-of-whack appraisal that arguably could have been put forth by a the appraiser that you chose in this case, correct?
In part, yes.
Okay, so wouldn't that be giving, wouldn't that render the term disinterested in this contract meaningless if all we can just not worry about that term and just let the umpire correct any errors that occur during the processing of the claim?
No, it would just be that disinterested doesn't mean that they can't be paid on a contingency fee basis. And if that is what they mean, they could have added in the policy, as other insurance companies have done. They specified how the neutral umpire is to be paid. So if they're going to go into a contract with an insured and then say, hey, if we're going to go in this appraisal process, you're required to pay somebody out of pocket on an hourly basis, they could have added that. But to stretch that disinterested and stretch it to how you are able to hire somebody to pursue your claim and say that somehow goes all the way to the method of payment, and even though Florida has set up public adjusters to be available to help homeowners that you can't hire them, then they should have added that. And you know, you go, obviously if its term is not defined, you go to the definition. There's no definition saying that you can't hire a public adjuster or somehow controls how you compensate somebody to be able to pursue your claim. So then you get into just apply, if you apply the straight definition, it can't be stretched to how they're going. And if you go down, if you look at the rules of law regarding ambiguity, certainly they could have added that provision in there. Other insurance companies have, but they did not, and they did nothing to put their insured on notice that if you want to actually pursue your claim, you're going to have to go out of pocket to ever have a chance to recover the payments that you're owed to repair your home. And that's the important distinction in this case. So as I said, I believe it can very easily be affirmed because it wasn't, a lot of these issues were not raised in detail.
Are there potential ways to recover costs?
Only other alternative would be litigation, which defeats the whole purpose of appraisal. You know, the reason you have appraisal is that so homeowners can do what this homeowner tried to do, which is get a public adjuster. The public adjuster tried to go through appraisal, which is what you hope for, so that they can get it resolved without litigation. And then if that public adjuster can't agree with State Farm, then they go to an umpire. And then, yes, the policy provides that if they have to go to the umpire, the homeowner is going to have to go out of pocket in some amount for that umpire. They're at least on notice of that. If you adopt State Farm's position, this insurer would have to then go on to hire another person hourly to pursue the appraisal award, go all the way through the appraisal, incur all that time. If they don't reach an agreement, then hire an umpire, and then incur even more costs. And you're talking about almost all homeowners having essentially nothing left to repair their homes. And don't be surprised that they're aware of that. And if the entire purpose of appraisal is to make it so that litigation is not necessary, and if you look at this case, every option was taken to try to preclude that from happening, and then they shut it down, and if they're affirmed, the homeowner's going to have to go back, she's going to have to go find somebody, pay them hourly to pursue the appraisal. They can't agree, pay somebody hourly to do the neutral umpire and be left with no monies to repair the home. And that's a situation that every homeowner will be if that stance is taken. And it's completely contrary to the purpose of appraisal. Thank you.
Thank you.
If I could just start backwards, because I heard Mr. Struble and Judge Cohen, you asked the question about fronting costs, or is there another way to cover costs? I am certain that Mr. Struble fronts costs in the cases where he represents insureds and then recovers them after the fact under Section 627.428 if there is a recovery or a judgment on behalf of the insured.
Then that would necessitate litigation, would it?
It
not?
would, litigation is existing in this case. To answer your question about fronting costs, the contract itself, the appraisal contract, insurance contract, says reasonable expenses of the appraisal and the reasonable compensation of the umpire. So you have appraisal costs plus the umpire shall be paid equally by you and us. And in this case, State Farm didn't invoke appraisal. It was the insured. So these
State Farm could have.
could have. You are correct, Your Honor. But we don't have that situation here where State Farm invoked appraisal, and those public policy arguments that Mr. Struble advanced were never fleshed out by a record below. There's no evidence of an unavailability.
But I think they're worth discussing at this juncture.
Okay. Well, discussing them would require avoidance of the term disinterested. Judge Wallace, I think you asked about the umpire question, and you're exactly correct. And the trial judge, in this case, I think was swayed by, if you read the hearing transcript, was swayed by the argument that don't worry about that word disinterested. Everybody can have their own, bias, partial, and people with pecuniary interest because the umpire is going to fix it. But that doesn't give value or doesn't recognize the word disinterested. The first step.
When State Farm picks an appraiser, do you think they pick somebody that they perceive as disinterested?
I do, Your Honor, and this is why. In this record, because we can talk broader, but I can talk specifically from this appellate record, the adjuster who walked the property with the public adjuster, the State Farm adjuster who walked the property, was named Kylie. That's the last name. It's in the record. It's attached. It's in our motion to compel, and we have letters and exhibits in the record. The public adjuster walked that property too. After that inspection, State Farm issued a letter and said it's under deductible. The public adjuster said, oh, I walked that property. Here's an estimate. State Farm reviewed it and said, okay, we'll give a little bit more money, and now you're above deductible. We're going to tender a payment. The public adjuster demanded appraisal and said, I'm naming myself. State Farm did not name Kylie. The adjuster who walked the property went out to an independent group called ICC Group and named a gentleman by the name of Kevin Duran, D-U-R-E-N. He's not paid based on his outcome in the appraisal. He doesn't get like a reverse contingency, right? If it's 5% less than the estimate, then you get an extra $100. You know what I'm just throwing numbers out there, but he doesn't get a reverse contingency with a favorable result.
Listen. Yeah, when State Farm requests, IMEs and personal injury cases, they know who they're getting, just like they know.
As do plaintiffs, right? There are certain reputational.
Yes, there are.
Yes. So, but I think that what State Farm tries to do is, I know this, I don't have to say think, you have it in the record before you. They go outside of their institution, they don't name their own, but that's what the public adjuster was doing. The public adjuster is the agency for the insured. So I thought it was interesting, one of the arguments that I heard was,
Isn't the result, though, the potential result of this decision to increase litigation?
No, Your Honor. Actually, I think the result will give clarity to the Wild West of appraisal. That's what I think. I think the result of this decision would be consistent with the jurisprudence in Florida as it stands right now. From the Bronco decision in 2014 from this court, from Sanders, from Valenti, it is a logical conclusion that the word disinterested has meaning, and no party and no court can rewrite a contract, insurance or otherwise, can't insert unless it's ambiguous.
If by statute a public appraiser is compensated from a percentage, on a percentage basis, how is a public adjuster ever qualified as an appraiser?
Right, and I'm glad, thank you for that question, because I wanted to clarify the record. I did not concede that a public adjuster can always serve as an appraiser. What I did say was, in answer to Your Honor's question, Judge Cohen, you asked me if he could ever, and I said yes, under certain limited circumstances, and the ones that I envisioned were those where he didn't have a contingency fee outcome and didn't have a pre-appraisal.
Does the statute provide a specific basis for payment of public adjusters?
I would like to look at the statute. I wish I had it in front of me. I know it says that it can't exceed 20%. That's what it says. It says it can't exceed. And so oftentimes you see these boilerplate appraisal contracts, they have 20. In this case, it was 20 with a line through it, 10. So maybe it was negotiated by the insured. We don't know. It's not in the record, but we know that it went from 20 to 10. The statute puts a cap on their contingency fee. Do I think it prohibits a public adjuster from serving as an hourly appraiser? I don't think so, but I don't want to represent that without studying the statute on that precise issue. I do know that there are adjusters, and this is not in the record because it wasn't, as I indicated before, it wasn't part of the record developed by the plaintiff who filed the action, who could have said, hey, I've got a public policy argument, I want to, and I'm not going to suggest how they would develop the record, but they didn't. There was a point I was going to make about that public adjuster. I think that the insured could retain other competent individuals, general contractors, engineers, plumbers, to serve as competent appraisers. They don't have to be public adjusters, that's,
All right, but at that point, unless you have a lawyer who's going to be fronting the costs, the homeowner is out of pocket.
and that's what the contract agrees to. That's what the contract agrees to. The contract says that the reasonable costs, reasonable expenses of the appraisal, and the reasonable compensation of the umpire shall be equally by you and us, meaning
But
State Farm's going to pay for theirs.
However, the homeowner could utilize a public appraiser who agrees to work on a contingency fee, then they're not out of pocket, correct?
They would be not out of pocket, but it would depend on that, on the appraisal or the adjuster's agreement. When you tie the outcome of the award to how much that adjuster or appraiser is going to be paid, just by the very definition, or by those terms, you are creating a conflict, and that's creating an interested.
You talk about reputation in terms of who insurance companies hire.
Right.
Effectively, it's the same concept. The amount of work you get is going to be dependent upon how the results the insurance company gets is perceived.
There's no, there's,
I'm just, that's
Yeah.
common sense. That's just when you talk about reputational. that
right,
you're hiring
with
people.
experts.
With
With experts, right.
Well, this,
This is I think, Your Honor, this is a more narrow issue. I really do. I think it's a narrow issue. I think it's driven by the plain term of the contract. And I think it is common sense maybe on the other side of the coin that is more compelling, which is that when a person receives more money based on the amount of that award, the person has a direct interest in the outcome. While that person may be a competent appraiser, he is not a disinterested appraiser. I can't take credit for that quote. That came from the 4th DCA Judge Kuntz's concurrence. We ask that this court give meaning to the word disinterested and reverse the trial judge below who overlooked the word and gave or elevated the umpire's role in the appraisal process. That's not what the contract says, and it's not what what was agreed to. And so we ask that you reverse, remand with a decision that follows Bronco and that follows Valenti and Sanders. Thank you.
Thank you for your arguments, and we're in recess.